Rules for what constitutes discrimination in the workplace just changed. I spent my morning going through the Department of Justice's Office of Legal Counsel's 20-something page opinion on what plaintiffs are going to have to prove or overcome to show they've been discriminated against by an employer. There is some material aspects collectively that I do think is going to make the burden more difficult on a plaintiff to prevail, and is going to put the company in the driver's seat on these types of suits moving forward. So let's start with the old rule. The old rule essentially said, hey, if you have some sort of hiring practice, whether you're looking at certain testing, educational requirements, physical fitness tests that are disproportionately impacting, the disparate impact is what the law calls it, a protected class, sex, gender, sexuality, religion, race, we very well may have a problem here, and plaintiff, as the court system, we want to hear from you. So you have some sort of hiring practice that results in 85% white candidates prevailing, but only 15% of black candidates prevailing. We have a problem here. Now, the business has always had a defense. It's called the business necessity defense. And essentially, you just show that this may be the unequal impact, but it's not intentional, and we actually have a valid purpose for it. Here is an actual valid purpose, sort of the law school 101 example. You're trying to go for your local fire department, and as a part of that test, they require a physical fitness test where you have to carry, and I'm making this up obviously, a 175-pound object out of a second story floor. You don't go down the stairwell, you take it outside. And women begin to sue because they say, this is disproportionately impacting us because 75% of men pass this test, but only 25% of women. And the fire department goes, yeah, but we have a really valid reason here because the average size of a person in their 30s coming out of our mini two-story apartment buildings in the city is about 170-something pounds. So we need this to be part of our test to make sure we're protecting the community. That's a valid business purpose. So let's fast forward here. What's the new rule? Same deal, but what I think this opinion does is it really highlights the corporate or employer's defense. So they spend 20-something pages talking about how this defense should essentially be valid if the business can show any reasonable purpose for it. On the old rule, I would say, hey, the business, if you got a facially neutral hiring practice that is leading to a disparate or unequal impact on a protected class, you have a problem, and your valid business purpose better be like the one I just gave earlier. I mean, super simple to understand, super clear, no room for argument, or you're going to lose. Under this new rule, I would say, plaintiff, you have a hiring practice or policy that is leading to a disparate impact, and you are the employer. I think as long as you can show just a rational basis for it, that's a much lower burden, it's much less scrutiny, you're going to prevail. This does not overturn 40 years of precedent. I would call this a roadmap to future litigation. You will see well-funded plaintiffs testing these theories in the court system to corporate clients. My corporate clients, I'm not going to speak to other corporations, is when you make a hiring decision, it is so important to keep your meeting minutes or your resolutions or memorialize why you did it. And also just do the right thing. But you could be in a perfect position and have done everything for the right reasons. If you're not memorializing it in real time, after a dispute arises, you may be a little bit exposed. So those things, they take extra time. It can be a little bit costly, but it's just a great practice. And when that lawsuit does come, you are just such a stronger position.